Recorder has started. All yours.
Thank you. Good evening. This is the April 16, 2024 special meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 4:46 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Meeting decorum. Any member of the Task Force Compliance and Amendments Committee may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Member Wolf, that completes my announcements.
Okay. All right. Let's call item 1.
Item 1, call to order, roll call, and agenda changes.
Okay, any changes or adjustments? Well, let's call the roll. We'll call the meeting to order. Let's see, call the meeting to order at 4:47. Let's call the roll, and then we'll move to agenda changes.
The meeting was called to order at 4:47 p.m. Taking the roll call, please. Chair Wolf.
Present.
Chair Wolf, present. Member Pilpel.
Present.
Member Pilpel, present. Member Anderson.
Present.
Member Anderson, present.
Okay.
Chair LaHood, absent. You have three present. You have a quorum.
Very good. Thank you. Any changes or adjustments to the agenda?
We received notification on Saturday morning that Mr. Svernov was unable to attend. He did request rescheduling.
Okay. Anybody have any problems with that?
No.
Then.
Can I suggest we wait until 5 o'clock to do any continuances, since we told parties that we wouldn't act on it until 5?
Okay. We can do that.
Chair Wolf?
Yes.
A couple of things. I think the minutes should reflect that you were asked to chair the meeting, which is fine. I had a couple of comments on the agenda just for notes.
Mm-hmm.
So on page 1 at the bottom, we've added the committee staff, which is great and fine, except that it cuts off and just has Cheryl's email and then 415-. So in the future, if we're going to use that template, can we just be sure that the phone number is there if that was the intention?
What page?
Page 1 at the bottom.
Oh, page 1 at the bottom. Oh, yes. Okay. That looks like a formatting issue.
Yeah. Nothing major else there. We'll get to item 2 in a second. Although we may well continue item 6, I just wanted to note the difference in description on item 5 and 6. So 5, if you just look for a moment, has a parenthetical italicized thing with the history action that the task force found a violation in February and what triggered the item tonight.
Mm-hmm.
I think that's totally helpful. And perhaps when we get there, we can talk more about formatting of the packet. But if you look at item 6, all it says is that the committee moved to continue the matter until the December meeting, blah, blah, blah. So I think it would be useful the next time item 6 or file 22020 appears is to have a similar history note showing on what date the task force found a violation and why this is back at the committee, that it's for a compliance hearing.
Okay.
Does that make sense?
Yeah, that sounds fine.
And if we do have a continuance, that's fine too, but at least sort of the why is it here question is better answered.
Yeah, perhaps a recap of what happened on October 24th.
Yeah,
right?
That's fine too.
Yeah.
And there may be, a similar continuance tonight, but just so that the record is a little more
Yep.
clear. And then finally, on item 4, which hopefully we'll spend most of our time on, I think it would be useful for that to have a better caption like Sunshine Ordinance amendments. And I have no objection to the link to the current code and even to the packet from a year ago. But I think that there was some information since then that we could have linked to, including the last big submission from San Franciscans for Sunshine, and I think the last working version that Chair LaHood had. So in the future, I think it would be great to have a PDF packet for that material. Does that make sense?
Makes sense. So noted, and we'll make sure that Chair LaHood is aware of that.
Okay.
Since she creates the agenda, helps create the agendas, and I don't.
Okay. That's all I had for the moment. Thank you for entertaining it.
Yeah, no problem. All right. Anything else? Member Anderson, anything for you?
No.
Okay. All right, great. Seeing those very minor changes, is there, let's since there was some discussion on the agenda, is there any public comment?
Are we moving to item?
No, we're since there was some discussion about making changes to the agenda, we need to have public comment
On item 1.
on item 1.
Understood. We do have one hand raised. We have no one in the room who has approached the podium. If you would like to speak and make public comment on item 1, just call to order, roll call on agenda changes, please approach. Otherwise, if you have something to say and you are in the online community, press *3 or raise your hand. Chair Wolf, we have one hand raised.
Okay. Let's have it.
Give me a moment. I will unmute them.
Apologies, Mr. Young. I have unmuted the individual.
Okay. All yours. You can handle it.
Hello, caller. Caller number 4. Would you like to identify yourself?
My name is Anne Trabeau, and my public comment is sounds pretty good to me. I appreciated that in the matter that's pending tonight, where I'm the complainant, that it was really a detailed description. So it was helpful for me also to be able to put things together.
Thank you. Did you have anything else?
Well, I don't think it's time yet, but for the agenda changes, I did note that the San Francisco police were requested to attend the meeting. So, you know, if they're waiting, maybe you could notify them also.
Thank you. All right, placing you on mute.
Okay.
Chair Wolf, we have no other hands raised.
Okay, great. Can we, since there is nothing substantive, can we take this by a voice vote?
Sorry, what's the proposed action?
Well, just that there was, you know, for the changes that you had suggested.
I'm not sure that there's any action needed on that. I think the only action is on the Svaranov matter, which we should probably address after 5.
Yeah, that's a different matter. Okay. All right. Then seeing that there were no changes, we will move ahead with item number 2. Ms. Peterson.
Item number 2, approval of the February 27, 2024 Compliance and Amendments Committee meeting minutes.
Okay. Any changes or adjustments to the minutes?
So, Chair Wolf, on this, the good news is we made some progress in the last 2 months, and in particular since the last meeting and in the last month, on how minutes are addressed. The bad news is that we didn't quite get there. I turned in some edits to these minutes last week. Those did not get worked on until yesterday, and I think Charla Hood has been pretty clear that she wanted to go through those in her absence, and there were some things that I didn't get to. In any event, I just don't think they are quite ready yet, and unfortunately, and so I would respectfully move to continue these to the call of the chair. I anticipate having these wrapped up in time for next month, along with the meeting minutes from tonight, so that hopefully we are on track. I don't think if the world ends, I don't think it'll be as a result of this particular action. So I would move to continue the minutes to the call of the chair.
Okay, moved by Member Pilpel. Is there a second?
Member Anderson seconds.
Okay, moved by Member Pilpel, second by Member Anderson. Any other discussion? Any other edits or additions? Okay, then we'll just continue to have this item continue to the call of the chair, and let's open it up for public comment. And this is public comment on to continue the minutes.
If there are any members of the public who would like to speak on this item, please approach the podium now. If you have a comment and you are in the online community, please press *3 or raise your hand using the app. I'll give you a moment. Chair Wolf, we have no one in the room and no hands raised.
Okay, thank you. Please call the roll.
Member Pilpel.
Aye.
Member Pilpel, aye. Member Anderson.
Aye.
Member Anderson, aye. Chair Wolf.
Aye.
Chair Wolf, aye. Member LaHood, Chair LaHood, absent. You have 3 ayes. You have the motion passes.
Okay, thank you very much. Let's call the next item.
Item 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. If you're in the room, please approach the podium. We currently have 1 hand raised. And it looks like 1 hand. Are you ready? Chair Wolf? I can unmute the caller.
Yeah, sure.
Hello, caller. You have been unmuted.
Hi, you guys. This is Ann Trudeau. I know my situation is a little unusual than most people's, but I think you already discussed this issue before, that when the agenda for meetings is going to go out, that instead of making a mass email, that you notify the respondents individually. But for me, I've gotten a number of emails from respondents that I have nothing to do with. A lot of them are full of anger and kind of abuse, and it's kind of a little upsetting to get these kind of emails. They're just clicking reply all, and it's hard for me. I have to come down scaffolding. I have to travel like 40 miles to get internet service and to read this nonsense. It clouds up my thing. It's just, if you could really do that. I know it's a little extra work, but maybe it's a good idea to just email the respondents separately instead of a mass email.
Thank you. Chair Wolf, we have no other callers.
Okay, very good. Then we will close public comment.
Chair Wolf,
Yes.
can I just follow up on that briefly to Pat and Victor? Have we in fact changed our procedures so as of now we're notifying complainants and respondents individually and not by a mass email? Is that correct?
Mr. Young, may I defer to you?
Yes, it is our intention and instruction that we only, when we send out notice of hearings, we send it out one email to the respondent and complainant in one email. And we do note the file number on each email. We attempt not to do mass emailings, and if we do that, we do a BCC.
Got it. Okay, excellent. Thank you. Good fix.
Okay. Moving on, next item, number 4.
Chair Wolf,
Yes.
could we, I don't want to delay. I really do want to get into the meat of 4, but perhaps since it's after 5, could we maybe deal with item 6, maybe come back to 5 and then come back to 4?
We certainly can.
Does that make sense?
Mm-hmm.
Okay. I'm assuming that 6 is going to be really quick and 5 isn't going to take that long. I hope.
I'm sorry, do you want to do 5 and 6 before 4?
That's what I was thinking, but
okay.
open.
Okay.
The suggestion is to hear item 6, then item 5, then item 4.
Yes, no, I understand. I'm just wondering if the both parties are here for item number 5.
Well, again, maybe if we dispense with 6 first, then we can
Okay.
deal with 5.
Okay. Well, let's do that. 6 is, we already know what the disposition of 6 is. So shall we move to continue that item?
Yes, and for your information, for item 6, Lieutenant Chris Beauchamp from the police department is in the room.
Okay.
That's why. Yeah. Okay.
Okay. Very good. Lieutenant, do you have any?
Why don't we call the item first?
Okay. Yes, call the item first.
Item 6, file number 22020. Hearing on the status of the order of determination. Complaint filed by Sergei Severinov against the police department for allegedly violating Administrative Code Sunshine Ordinance, sections 67.21 sub C, by failing public records request in a timely and or complete manner.
Please read the rest.
On October 24, 2023, the Compliance and Amendments Committee moved to continue the matter until the December 19, 2023 Compliance and Amendments Committee and request verbal confirmation from the police department that a representative will be in attendance at that hearing.
Okay. Lieutenant, you are here? Yes, looks like you've been moved to the stage. Okay, we've been, there's been a request to have this continued. Has this been the first time? Do we know if this is the first time it's been continued? Has it been continued before? Other than the task forces or the committee's decision?
If you give me a moment, I'll look up the history, but please proceed while I look.
Okay. Lieutenant Beauchamp, do you have any concerns about this being continued?
Oh, none whatsoever. Thank you.
Okay, great.
Almost there. Give me one moment.
Okay. I'm just wondering if the complainant had requested a continuance of this before or not.
Okay. On 6/27/23, CAC had a hearing and moved to continue the matter. On 10/24/23, scheduled before CAC, and was continued on that date also. On 10/24.
Does it say whether it was the complainant who requested?
I don't have that kind of detail. I can look at those minutes quickly. Let me see if I can find anything. Okay, 10/24/23.
Mr. Young, we heard 1024.
10/24/23. It looks like the petitioner did provide testimony at that time. And then I'm going to look at the previous continuance, which was 6/27/23.
Yeah, I'm just looking at the order of determination, has the chronology on it, actually. Recommendation.
Yeah. Chairman Wolf, it looks like on February 27th of this year.
Yeah.
On February 27th of this year,
Yep.
that we heard this matter, and what was supposed to happen was that Lieutenant Beauchamp was to provide within 5 business days to Mr. Severnov the body cam footage and the records identified by the committee. And the committee requests that all incident case reports associated in item 6A of the letter dated June 21st in case number 0509719112 be sent to Mr. Severnov, that there may be redactions. And we just requested that confirmation of this exchange be sent to the task force administrator. And I believe, did we keep this on our agenda, or we continued the matter just to see if those things were done?
I guess so.
So we can ask Lieutenant Beauchamp, were all those things done?
Yes, ma'am. I sent a email on the 4th of March to the SOTF and Ms. Ledger with confirmation that I had sent both the links for the BWC and the requested 12 instant reports to Mr. Severnov.
Thank you.
I'm sorry, and can you just point us very quickly to where that is in the packet? I think I remember seeing it, but I'm just looking for the page.
It's on page
51?
No, it's on page 2 of 112.
That's
Right,
the
no,
order
no.
of determination.
Yeah, no, that I saw, the police department email.
No, not in the packet.
Oh, that's what we were
That's what I was
looking
looking for.
for. Right.
I see, wait a minute, let's see. I see one from on page 65 of 65 of 112.
Okay.
There's a March 1st, 2024. Lieutenant Beauchamp, is that the letter you're referring to? It says, I'm finishing up pulling together all the reports requested by Mr. Severinoff?
I think it's the following page 67.
Yes, I sent the information on the 1st,
Oh.
then I sent a letter to,
Got
no,
it.
an email to SOTF on the 4th.
Okay.
There it is, page 67 of the packet.
Yes. Okay. Well, Mr. Severinoff is not here to confirm that. Members, what's your pleasure?
Couple of things. It seems to me like in this case, the police did exactly what we asked, which was to provide the body cam and confirm if there were any other records and send a message to the task force confirming that. I mean, at this point, I'm satisfied. I could either support a continuance if we have to, but I think my preference would be to just close the matter because they did what we asked them to do.
Mm-hmm.
I would also suggest going forward on these compliance hearings. Let me offer another thought about compliance hearings in general after we're done with
Okay.
the position of this matter.
Okay.
I mean, I guess Mr. Sverinoff can ask for a hearing, and it would be up to Chair LaHood whether or not to recalendar it. But again, I think we asked the police to follow up 2 months ago. It appears that they did, and we should be rewarding people who do what we asked them to do. So I'm inclined to close it.
Make a motion.
Yeah.
All right. Based on that, I would so move that we close the matter. And hold on a moment. Let me go to our new flow chart. Thank you, Victor. Page 4.
What flow chart?
This is from an email. It's a thing. Is it
Okay.
is it that I'm moving to find that the police department complied with the order of determination and close the matter? Victor?
Yes, I believe that would be the correct motion. And Member Wolf, I will resend a copy of my template motion chart to you shortly.
Okay. Thank you.
Do we have a second?
Second.
Seconded by
Moved by-
Member Anderson.
Moved by Member Pilpel, second by Member Anderson. To find that the items, I'm sorry, what was the statement that's on the flow chart?
I think it's to find that the police department complied with the order of determination and closed the matter. Does that sound right?
Yes.
Sounds good to me. Okay. Let's open it up for public comment.
If there are any members of the public who are in the room who would like to make public comment on this item, please approach the podium. If you are in the online community, please raise your hand using *3 or use the app to raise your hand. We currently have one hand raised and no one in the room. Hello, caller, you've
Okay.
been unmuted.
Yeah, hi, this is Ann Trudeau. I support this motion to close the matter. I find it a little distressing that the complainant didn't even write a letter to say, look, I got the documents, please close it. Instead, he wants a continuance. And this is what makes San Francisco unique, that a lieutenant would take his time out to sit in a room where this kind of high-ranking person could be doing something more productive or beneficial to the community. And in other cities, you don't have a lieutenant that would spend his time on a sunshine matter like this. So I just want to support the motion, and hopefully you know, this complainant would learn, you know, not to waste people's time like this. That's it.
Thank you. Shall we move to a vote?
I'm sorry, I was on mute. Are there any other discussion, members? Hearing none, are we ready for a vote? Okay, please call roll.
On the matter, on the motion by Member Pilpel, seconded by Member Anderson to find that the police department complied with the order of determination and closed the matter, taking the vote. Member Pilpel.
Aye.
Member Pilpel, aye. Member Anderson.
Aye.
Member Anderson, aye. Chair Wolf.
Aye.
Chair Wolf, aye. Absent, Member LaHood. 3 ayes, the motion passes.
Okay. Member Pilpel, I know you want to address some general comments. I'm wondering if we could get through the next item and then take those comments so we can let folks move on their day.
Absolutely.
Okay, great. We'll come back to that. Okay, let's call item number 5, file number 20008.
Item number 5, file number 20008. Hearing on the status of the order of determination. Complaint filed by Ann Trabeau against the Office of the City Attorney for allegedly violating Administrative Code Sunshine Ordinance Sections 67.25 and 67.27 by failing to respond to an immediate disclosure request in a timely and/or complete manner. On February 7, 2024, the Sunshine Ordinance Task Force found violations of Administrative Code Section 67.21 and ordered the release of the augmented brief dated October 16, 2019, and the response to the amicus brief dated November 22, 2019. The petitioner requested a hearing as they do not believe the documents provided comply with the order from the task force.
Okay. Are both parties here? Ms. Trabeau? Can you move her to the stage, please?
Moving her to the panelist.
And I believe it's Ms. Court also. Okay, are both parties here? Oh.
Yes.
Okay. Please unmute Ms. Trabeau.
Hello?
Yes, we can hear you now.
Hi. Firstly, the order of determination.
Hold on a minute. Hold on.
Okay.
We got to set you up with the clock, but I want to make sure that we can hear the respondent.
Hi, this is Jen Court from the City Attorney's Office.
Okay, great. Okay, we have both parties here. Okay, let's please. So let's hear from Mr. Bowe, since you had requested this hearing. I'll give you a few minutes to explain what the issues are.
3 minutes, Chair Wolf.
Yes, please.
Ms. Trabeau, your 3 minutes begins now.
Firstly, the heading should say Dwight Moore of the City Attorney's Office. That's how the order read, and it should be consistent throughout. The issue at hand here is a long-standing issue with the City Attorney's Office. The documents that were turned over didn't have the court stamp on them. Therefore, they are not public documents. This is problematic because the if the documents don't enter the public domain, they are not public documents. So it's too easy for the respondent to say, well, we turned over everything in our possession and we don't have to go hunting for other documents. Well, yeah, possibly they do, because I did come to San Francisco the day of the hearing. I spent a couple hours in both the trial court public viewing room and the California Court of Appeal public viewing room. And the documents in the docket or register, as you call it in California, were not consistent with the documents that were turned over to me, first off. Second off, and the main thing, in both the trial court and the Court of Appeal, there were documents that were in the file that had no court stamps on them. And these would be important documents like a restraining order, like a proof of service. The city attorney's office typically files them electronically, and there would be a stamp, and it was received on such and such a date by such a clerk. There were a number of documents apart from the motion to augment and the response to the amicus brief that they were ordered to turn over. So I just wanted to make it clear that, firstly, if a restraining order does not have a court stamp on it, it's not a public document, which directly pertains to the Sunshine Task Force. But additionally, if this unstamped document is sent to the legal department of the San Francisco Police Department, it's unstamped and they cannot file it, and therefore it's not a legal document and it's not enforceable. So that has been a long-standing problem with the city attorney's office, and it's the response from the respondent is going to be, well, we don't have to turn over documents that's not in our possession. Well, they did not comply with the order because there were no court stamps on the documents that they did turn over.
Your 3 minutes is up.
Done.
Thank you. And let's give Ms. Court equal time.
Ms. Quart, are you ready?
Yes, I am.
Your 3 minutes begins now.
Thank you. Good evening, committee members. So as you know, at the February 7th meeting of the full task force, the task force ordered the city attorney's office to produce 2 documents from an appellate court case which Ms. Trabeau initiated. Those 2 documents were the motion to augment filed on October 16th, 2019, and a response to an amicus brief filed November 22nd, 2019. With regard to the court stamp issue, the first document, the motion to augment, is court stamped. You can find that on page 199 of this item of your packet. And then with regard to the second document, the response to the amicus brief, that is not court stamped, but that is the only version of this document that the city attorney's office has in its possession. As we noted in the task force hearings on this complaint, the case that Ms. Trabeau is seeking records about is pretty old. It has been closed for several years, and the attorney working on that case is no longer in our office. So we're only able to produce the records that we have in our possession, and the Sunshine Ordinance does not require us to seek out additional records from third parties to then produce to a requester. Ms. Trabeau has the same right of access to court records that any other member of the public does. And so if she's seeking records that the court has in its possession, she can request those records from the California Court of Appeal. However, our office has produced both of the documents that the task force ordered us to produce in a timely fashion. We don't have other versions of these documents in our possession, and we hope that this demonstrates that we've complied with the task force order. And with that, can answer any questions you have.
Okay, thank you. Members? I'll start. Ms. Court, I'm looking on page 199. I don't see a stamp.
So it's at the very top of the document.
Oh, I see. It's not a rubber stamp. Okay. Got
Right. It's electronic. Yes.
Got it. Okay. Thanks.
Um,
And did you direct or help assist Ms. Chabot as to where she could find these documents? Or did you just provided what you had?
So we provided what we had, but I believe over the course of the hearings on this matter at the task force and in other forums, we've said multiple times that she could seek these records from the California Court of Appeal.
Okay, very good. Thank you. Member Pilpul, I think you wanted to chime in.
So it's a bit confusing in the packet. I think there's some duplication. But in any event, if we can go to page 99 of the packet, I believe that's the February 9th, 2024 email from Ms. Court to Ms. Chabot, copy to the task force, following up from the February 7th task force meeting with the relevant documents at length, including all the exhibits, yada, yada. And then going to page 196 of the packet, that appears to be a follow-up letter dated March 20th from Ms. Court to the task force, kind of rehashing the history and better explaining, as I think we just heard Ms. Court say, that the one document is court stamped and the other is not, but it's the only version, blah, 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 with, again, some of the documents with exhibits. Ms. Court, am I catching that correctly?
Yes, that's all correct. And the motion to augment that we produce is on page 199 of your packet, and the answer to the amicus brief is on page 207.
Yes, all of that, correct. So thank you. So to Ms. Chabot, if they do acknowledge receipt of the February 9th email, and have you reviewed the March 20th letter from the city attorney to us?
Am I unmuted?
Yes.
Because I'm not in a place where I have easy access to the internet, I actually didn't pick it up until later. But nowhere in those letters was I referred to the court. I have easy access to travel to San Francisco to go into the public records room. Nowhere in any of that correspondence is any verbiage even remotely related to that. So, no, I was not referred elsewhere for that reason. My issue, and I raised it in an email to respondent, is that these are not court stamped, and for her to push it off and say Margaret Baumgardner no longer works with the office, the order was not complied with. The bottom line, there's no court stamp on that document. It's not a public document, so the order was not complied with.
Well, okay. So let me just break that down a little bit. On the motion to augment, one moment. Sorry. Okay. The city's motion to augment, that's on page 199 of the packet, among other places, is court stamped. So that is what appears to be the court stamped version of what the city filed in that action. Okay.
Correct.
Okay. So we're good with that one?
We're good with that one.
Okay. So then the only issue, it sounds like, is the response to the amicus brief filed November 22nd. That's in our
That's right.
packet. That's in our packet starting at page 207. The city has just explained that they don't have a date stamped version of that for whatever reason. This was a filing from almost 4.5 years ago. And they believe, I guess they believe that it was properly filed and it may be available in the court's filing system. I can't remember if it's File and Serve or True Filing or Happy Filing or whatever it is. But in any event, that's what the city has, and they provided that with all the relevant attachments to you. I don't know. I think that's all we can ask them to do.
Firstly, Member Pilpel?
Yeah.
Can I speak?
Yeah.
Okay. First off, as you know, I am more than 3,000 miles away. I did pick up the letter. It there in black and white is no reference, well, you can just go into the public records room yourself and pick it up. There is no verbiage like that. So we can push that aside as a falsehood. Second off, as we all know, people that study the Sunshine Ordinance, that know it a bit, we know when somebody is asking for a record, a document, these are, particularly in court matters, they must be stamped. So it's too easy for this woman to blow it off and say, oh, well, somebody left the office and we don't have to contact her, even though she works in the sheriff's department. And, this is yet another mistake. That is not a public document. I asked for all court documents in the original IDR. A court document is a stamped document that's entered with the court. For her to say, oh, we don't have it and we don't have to produce it, what steps did she take? What were her methods in looking for it? Who did she work with to try and find it? You know, all we got throughout this whole case was delay, delay, delay. We don't have time. We can't put it together. We. Who's the we? Who's she communicating with? It wasn't Margot Baumgartner, that's for sure. So it's just smoke and mirrors. In my point of view, the original IDR was not complied with because I asked for court documents. That document, the response to the amicus brief, was not stamped. She had an obligation to look for it, do some research to try and find it, and up until this point, we haven't heard what method she used to find it. We don't know because she just, I would like an answer to that if you don't mind.
Thank you.
Chair Wolf?
Yes.
All right. So can I just ask one more follow-up to Ms. Port? I would really like to put this to bed tonight if we can. So can you just, as the kids like to say, can you share with the group what there is, if this is all there is, a little bit on what your office did to try to find stuff, and maybe point out either verbally now or maybe follow up with an email to Ms. Trabeau about what other avenues she might have. I am generally of the view that you've done what we asked, but if you can just elaborate on that a little bit, that would be great.
Sure thing. So I think I'm going to take your second question first because I realized that in the March 20th email that, the March 20th letter that we provided to Ms. Trabeau and the task force on page 196, in the second to last paragraph, it reads, Ms. Trabeau has the same right of access to court records as any other member of the public. To get those records, she is free to request a court stamped version of this document from the California Court of Appeal. So that's the second issue. The first issue in terms of just like what we did to find these documents many years later, we essentially have a drive, a shared drive in our office that it contains all of our litigation files, and it's broken up by matter, by the litigation that we're talking about. And the attorneys who are working, the attorneys and the paralegals who are working on those specific matters, only they have access to that drive for that individual matter. That is to prevent us from learning about things we shouldn't be learning about if there's a due process screen in place. So for this matter, we had our IT team give those of us who work on public records matters access to the file for this matter, and then I went through all of the files that are in that folder myself looking for these documents, and these are the only two versions that we have.
Okay, thank you.
No problem.
So in summary, although I assume that Ms. Trabeau is not happy with this latest turn of events, I think if the city attorney's office did a diligent search in the shared drive of that particular litigation matter and found only these particular records, one of which was date stamped and provided, and one of which was not date stamped and was still provided, and included in the letter how Ms. Trabeau can get access to the records from the court. It seems like the city attorney has complied with our order as relates to this as a compliance matter. It's not perfect, nothing is, but it's the best they could do. So, you want to make this one?
Okay, any other discussion? Or is there a motion?
Chairman Wolf, yes, there is a motion. This is Member Anderson, and I move to find that the city attorney's office complied with the order of determination and close the matter.
Okay, moved by Member Anderson. Is there a second?
Second.
Second by Member Pilpel. Let's open it up for public comment. This is for public comment other than the parties.
There is no one in the room approaching the podium, and there are no callers in the queue.
Okay, so noted. Are we any other further discussion, members? Hearing none, are we ready for a vote? Okay, let's call the roll.
On item number 5, file number 20008, Member Pilpel. I'm sorry, Member Anderson.
Aye.
Member Anderson, aye. Member Pilpel.
And this is on a motion to find that the city attorney complied with the order of determination and close the matter.
And to close the matter, correct.
Aye.
Member Pilpel, aye. Chair Wolf.
Aye.
Chair Wolf, aye. Member LaHood, absent. 3 ayes, the motion passes.
Okay, thank you very much. Thank you, parties. Can we take a 2-minute quick break?
Actually, could I just make my comment about
Oh, yes.
compliance packets? All right.
Yes.
So I was thinking a little bit as we went through these last 2 cases and what was in the file. I think that there's a lot of paperwork, and whether it's electronic or paperwork, there's just a lot that goes into case files. I'm constantly thinking of ways to reduce that to stuff that is relevant to us at the particular time that we're looking at things. If we need to study 500 pages of stuff, so be it. I find that generally we don't need to be reviewing 500 pages of stuff, particularly if a bunch of it is duplicative. So what I'm thinking is when something has an OD, has been voted on by the task force, if it's sent to a committee, whether it's this committee or EOT, or is back at the task force for whatever reason, that maybe it is worth trying, and I'm interested in hearing from Victor on this in particular, to have 2 links in the agenda. One is a link to the final packet at the task force, which would be the pre-order material, like the original complaint, the back and
Member
forth.
Felto, I just would like you to know we have been addressing this with Chair Yankee.
Okay.
The thought is that we would include all the new documents as part of the packet, ODs, any letters and whatnot. And then in the packet cover sheet, we would put a link to the previous meeting.
That's fine. So what I was getting at is that whether it's one link or two, that what we would see in the basic packet for a compliance hearing, again, whether it's here or EOT or elsewhere, is just the post-order material, starting with the order, follow, and in addition, anything from the complainant and respondent that's post-order, whether it's a communication, a copy of materials, the notice to appear, all of that, so that we don't have to start out with the old history, but we can just start with the point of the order and just take it from there. That's kind of the direction that you're going?
Yes, that is the intent.
Okay, that is fabu and fantastic, and I look forward to that, and I hope the other members do as well. I think the more we can focus on what's at issue now as opposed to what was at issue 2 months ago or 2 years ago or 10 years ago, the better.
Yeah, the other thing I would add to that is I really would like to see, if the rest of it needs to be included, that at least the pertinent items for the discussion of that meeting be pushed all the way to the top. Because it's like not knowing that there were new letters that were presented or submitted to our office in between the last meeting and this meeting, at least not having them notated on the cover page. It makes it a little bit difficult to then, have to traverse multiple pages to find it. And I appreciated Ms. Quark knowing exactly where it was, being prepared. That's fine, but not everyone is. I think it'd help us prepare also if all the newest stuff before coming after the previous meeting be moved to the top of the file.
Or if it's less stuff, then it'll be more obvious. But either way, yeah.
Yeah, or referenced. Yeah, that kind of thing. Okay. Member Anderson?
Oh, go ahead.
No, I pretty much believe that whichever way we go, whether we say just the materials from the first attachment or link to the attachment would be just the things between our original orders of determination and the meetings that we have here in a compliance and amendment, or we push that information to the top of the entire packet. As long as we get to the point where we don't have to go through, as in this case, over 200 pages of documents to get to the things that are really pertinent to what we're trying to discuss. So it would make it easier. Thank you.
And I agree. And I would even suggest, I don't want to make it more complicated, but if you go to page 4, what we've called the complaint summary, maybe there's an opportunity there to add to the complaint summary if there's been a violation found, to put in here what the code sections were that were found, and if there's an issue of compliance, what we've asked them to do, and to basically say in here somehow the issue before the committee now is whether the compliance order requesting has been addressed. Bang. Just so that it's really, really clear what we're actually doing, so that we don't have to spend time trying to figure that out. But whatever, I'll leave it to our capable administrators to figure out how better to do that. And if we're getting to a better place, better is good.
Looks like we're on that path.
Yeah.
So thank you.
Okay, great.
Thanks for taking the time on that, Bruce.
Yeah, no problem. If we can have 2 minutes, I just need nature call 5. Okay.
5.
5 minutes, and we will return at
In about 5 minutes.
5:50.
There we go.
Okay, we're in recess.
Thank you.
Okay, we're back. Okay, I will verbalize as Bruce Wolf, chair for tonight of the CAC. And I see Member Pilpel and Member Anderson in the room. So let's continue on with our next item, number 4.
Item 4. Committee members will review the Sunshine Ordinance and discuss possible amendments to recommend to the full task force. Recommendations proposed by members of the public at previous committee meetings will be taken into consideration.
Okay. Where did we leave off?
So, Chair Wolf, I have in my notes that last time we discussed item 67.8 and 67.8-1, and that tonight we were going to start with 67.10, 11, and 12, and then come back to 9 and other sections. That we're going to try to get through all of the other outstanding issues related to closed sessions. Does that sound about right?
That sounds about right.
Okay. In the absence of Chair LaHood, perhaps Person Peterson can take some notes that will work into whatever version. I'm not sure that we need to wordsmith everything, but maybe just some general notes tonight, and we can always review the tape. I'm sure this isn't the last time we're going to talk about amendments to the ordinance.
Member Pilpel, that's not really something we can do because we don't want to interpret. We're happy to keep an outline.
That's fine.
Okay, no problem.
When I said notes, what I meant was outline. See?
Well, we also have the audio to refer back to. Also.
Back to you, Chair Wolf.
All right, let's see here. Okay, so 67.7 you said?
No, I'm sorry. We did 67.8 and 0.8-1.
No.
And I think we were going to skip over 9 for a moment so that we could do 10, 11, and 12, all of which deal with closed sessions, and then come back to 9.
That's right.
And
Okay.
And just so you know, former Chair Washburn is in the room with us.
Yeah.
For which we are very appreciative.
All right. Okay, so let's move on with it. I would like to, let's see, it's 6 o'clock, coming on 6 o'clock now. Can we, is spending an hour or less enough?
I was thinking at least an hour and maybe an hour and a half, 2 hours, but why don't we see 1 hour?
Okay.
Okay. Why don't we do an hour?
Let's see where we are then. Okay. So 6710.
We could spend an hour in open session discussing closed sessions.
Yeah. Very, very good. Okay.
So
Would you
propose that we just start?
Yeah.
I was going to say, if we could just start with 67.10, I can give a little spiel about some thoughts I have. We can all chime in and then hear from Allison and then see where we are on that section and then move on. Does that work?
Yeah, that sounds fun.
Okay. So and let me just say in general on these sections about closed session, they're a bit all over the place. They're not all over the place, but they're not in any great order right now in the ordinance. 67.8 is currently titled Agenda Disclosures Closed Sessions. 0.8-1 is called Additional Requirements for Closed Sessions, and I think I articulated last time why I thought that whole section should go away and be folded into language in other places. Not that the provisions aren't important, but that it's just not a great place and they should be in a better home. 67.10 is called closed sessions permitted topics. 67.11 is statement of reasons for closed sessions. And 67.12 is disclosure of closed session discussions and actions. Some of which tracks with the Brown Act and some is takes a bit of a departure. Not a radical departure, but in any event. So I guess it's my overall thought that yes, we should have provisions for closed sessions. B, yes, they should be limited to only certain very specified cases. C, that we should track as much as possible to the Brown Act and shouldn't reinvent except where necessary. And D, that the flow in my head is something like what kind of like the permitted topics first. On what basis might you have a closed session? Okay, that might also, period, is permitted topics. Then I think the agenda disclosures. So once you've decided that you can have a closed session, how do you write that up in the agenda? That seems to flow. And then perhaps either the statement of reasons or what materials might you make available in advance of a closed session. And then finally, what disclosures do you make after a closed session, including both comments at a meeting, documents that are available immediately, documents that are available sometime later, et cetera, et cetera. So it's kind of like cradle to grave on the concept of closed sessions. That's sort of where I am. I'm open to other ways to structure it, but that's a bit of what I'm thinking. Mm-hmm. However that plays out in the writing. So going to 67.10, I don't have a particular problem with point 10 A and B. I think in B, on the third line, to hear complaints or charges brought against the employee by another person, I might strike or employee, because another person is pretty much anybody. 2 lines down, and shall exclude from any such closed meeting. I think I would replace the word meeting with the word session. I think that's understood. There's no such thing as a closed meeting. There is a closed session within a public meeting. 3 lines below that, or person providing services to the city as an independent contractor, or I think I would replace the with an, so it would read or an employee thereof. So those were the specific edits that I had in B. As to C, I want to make clear that my understanding is the Executive Compensation Committee that is referred to in this paragraph was, I think, part of an MOU that existed at one point with the Municipal Executives Association, MEA. I don't think it is still operative. I mean, we can find out. That's a pretty easy question to MEA or to the city's Employee Relations Division. I believe it is no longer operative, and if so, I would suggest that we eliminate that entire graph. I think
unless there's a replacement for it.
Correct. I just don't think that the point is, I don't think they're doing that like that anymore, if they ever were. And it may be that it never really existed. It was just created in the event that there was a need to have some kind of closed session to discuss performance as relates to a merit-based compensation increase, whatever. Okay. I'm happy to go find out offline if that's still happening. If it is, great, let's leave it or let's recraft it to make sense. And if not, my suggestion is let's drop it. moving on to what was D1, I think I just reordered the language, so I think I would have it read an adjudicatory proceeding before a court, administrative body exercising its adjudicatory authority, arbitrator, comma, or hearing officer to which the city as a party has been formally initiated. And I really didn't like the language initiated formally. That, for some reason, that just hurt me.
Mm-hmm.
Anyway, in the next section or subsection 2, third line down, against the city, comma, or the insert policy.
Before you move on, I have a comment on B.
Oh yeah.
Actually, on A, I was reading through. I think it was reading through the San Franciscans for Sunshine version, and they had some additions in there. I think that would be helpful. Unless you want to finish going through it, it's kind of, I guess you don't have too much longer. Why don't you finish what you had, and then we'll have Allison come up and.
I would like that.
Go ahead.
Okay. So on D2, a point has been reached where blah, blah, blah. 2 lines down, exposure to litigation against the city or just insert the word policy. So it would read, or the policy body is meeting only to decide.
I'm sorry, which one is this?
D2.
D2.
Third line.
Exposure to litigation. Okay. Mm-hmm.
So just add the word policy before body.
Mm-hmm.
On D3, first line, to just replace the word under with pursuant to. I think that was kind of a global fix that I suggested. In E1, second line, instructing its designated representatives and may take place. I think only would read better than solely. Solely, I don't know, just sort of reminds me of fish. That was all I had on E1. On E2, I didn't find that the prefatory, is that the right word? Whatever, the phrase at the beginning, I didn't find that to be necessary or useful, so I would just start with a policy body subject to insert California Government Code Section 3501, blah, blah, blah. And then at the end, as determined pursuant to insert California Government Code. And then capital S, or no, maybe small s, Section 3504. That's all I had for E2. Really just clarifying. That's where I was in my version. I'm happy to open it up to others, and I'd love to hear from Allison on 67.10.
Okay. Sure. Let's do it.
Okay. So I've been taking notes and we'll be happy to review the recording. I just want to make sure that I understand Member Pilpel's, he had some specific edits, but I wanted to make sure that I understood what he said initially, which is suggesting that these various sections about closed sessions could be organized in a way that flows better. So that would mean a kind of a bit of work there, but I made a note of that. It might be a good idea. And I went back and reviewed what has been done over the years. I have no way of knowing where some of these changes originated. Some of them may have been in this various this very committee like 15 or 20 years ago. But the major ones that I see, we didn't do the fancy line editing that member Pilpel did, but we did add something I thought that was pretty important to 6710B. We added that if a city employee subject to appointment, employment, evaluation of performance, or dismissal of a city employee requests a public hearing, it shall be public. So I think we think of personnel matters as being held in closed session. That's the way they're typically done, understandably. But we wanted to have that provision where if that employee wanted to have a public hearing, that would be permissible. And anything else? I made note of the Executive Compensation Committee, and there may be some places where some updating needs to be done. But as far as 6710, those were major changes, some minor wording changes in A, specifying it was the California Attorney General and so forth. Okay.
You also noted to add agency counsel, security consultant, in addition to sheriff or chief of police.
Right. And we also struck some material in B. Again, this has to do with personnel matters being heard. So we struck that the body may exclude from any such public meeting.
I think you replaced
I think we just, I think we just cleaned up B actually with our, it wasn't an addition so much as a clarification with what I read earlier. So
it made it more concise. I think you're
right. Okay. That's it.
Okay. And then
Chair Wolf?
Yeah.
So a couple of thoughts. I have not recently compared the language of the ordinance to the Brown Act. I would like to do that at some point. So where we can just track the language exactly, I think that would be good. Where there's a reason to depart, then we should. I just wanted to, I agree with what Allison just articulated. I want to be careful about the security concept because that had been more of a physical security issue back in the day. And I think that's now been broadened to include cyber and other types of security and intelligence. I don't want to get too far into all of that, but I want to give agencies some latitude to discuss appropriate threats and security measures in closed session that make sense under those circumstances. Does that make sense to everyone?
Right. So are you looking to expand the verbiage to include that, or?
I want to go back and see what they did in state law to address that.
Oh, I see.
First.
Okay. Yeah.
And if there's a reason to clarify it locally, then so be it. I mean, the point is, I am satisfied knowing that the PUC guards our watersheds and treatment plants and all that from physical harm. I also believe that the Department of Technology and the various departments are concerned about cyber incidents and, monetary theft through systems and whatnot. But I want to allow bodies, if they need to discuss that in a closed session, to be able to do it. And I don't want to know the particulars about it. Does that?
I understand what you're saying.
Okay. I don't want to give them too much rope there, but I want to give them enough that they can get their job done.
Yeah. But, there's the the other aspect of this also is how does that balance with the public's right to know?
Correct, which is why I wanted that to, which is why I don't think we should have too much or any latitude locally that state law doesn't already address. If they haven't figured out that this is a problem for all local agencies in the state, then somebody should figure that out in Sacramento.
Okay.
Apparently, there's some agreement on that point.
Somebody at the door.
All right. Anyway, one second. That's what I had on A. On B, I agree that I think a careful look at B and what's contemplated for the so-called personnel closed sessions is appropriate. I just wanted to note for our discussions here, the policy bodies that have hiring and firing or, more broadly, appointment, employment, evaluation, or dismissal authority over employees is incredibly limited in San Francisco. It is largely a department head that reports to a charter board or commission. In some cases, it's the commission secretary. In very limited cases, do the police and fire commissions have closed sessions to deal with their members and complaints against their members, and the Civil Service Commission has some authority over city employees. Generally speaking, boards and commissions do not have the ability to hire or fire subordinate employees, consider their performance evaluations, or any of that. So you might think that the MTA has plenary power over everybody who works for MTA, but that's not in fact the case. Same thing with all the other city departments. So this looks like it's a big deal thing, but in my experience, it really only happens in those extremely limited circumstances. But that's just my take on it. I think Allison has more thoughts to share with the group.
Well, just on that point real quick,
Yep.
I think for that one section where you had asked for it to be struck, the second, was it where was it? It said to
The
hear
Executive
complaints.
Compensation Committee?
No, B, in B.
I wasn't suggesting anything be struck there. I think Allison was suggesting better language about if an employee complained against requests of public hearing, then it shall be public. I don't have a problem with that. There may be, for all I know, there may be labor code provisions or MOU provisions that wouldn't allow that. I mean, this is the kind of thing that we should check with DHR about, I think. But I agree with you in concept that if an employee says, hey, I want this to be in public, I don't have any problem hearing it in public, then it should be. I don't have a problem with that from a policy perspective.
Yeah, it's kind of, even in general corporations, it's generally part of their, it's kind of a general practice. If an employee, if there's like a board of directors for a nonprofit, so to speak, that they could have a disciplinary or some discussion about their employment be done outside of an executive session. And I've seen that written in many, many bylaws. So I think it's kind of a general practice for organizations that have such type of deliberative bodies.
It may be, but there might also be provisions either in the MEA, MOU, or other collective bargaining agreements that don't allow that for whatever. I don't know. The city has labor attorneys. Mm-hmm. They do this all day long. They know that.
Could this whole matter be addressed by saying if an employee requests that their hearing be in public, it will be granted subject to any countervailing MOUs?
Something like that.
And that pretty much takes care of that whole question.
Yeah. Yeah, we can essentially say that our policy goal is to make it public, unless there's some countervailing
Exactly.
force. Yeah.
Exactly.
Yeah.
So that pretty
There are
much
ways to write
takes
it.
care of that.
All right.
Okay.
Is there anything else from you, Allison, on this subject?
The only thing, and this really applies to the whole ordinance, parenthetical additions like we've proposed for E2, where we mention in addition to closed sessions authorized by the government code section 3501. And then we've added as amended at any time or any of its successor provisions thereto. So, and this is analogous to what we need to have these clauses so that, it's a way to acknowledge that things may change and we recognize that. And, at some point in time, somebody will, be more explicit. But this is one place. I know there are many other places we've added that.
Yeah, that's reasonable.
Yeah.
Yeah, just in general, one of the things I meant to mention early on, I think it would be good at this point to also make notation as to which parts, which sections of the ordinance are stemming from the Brown Act or the CPRA.
Yes.
Because that generally the task force, focuses heavily on the ordinance, but it really needs to be also citing both the governing statute, and then if the ordinance has any kind of enhancement to it or is repetitious to it, at least both should be part of an order. And we had started to do that, but when, it takes some time for people to review and know the Brown Act well enough to know which corresponds. So I think it'd be a good idea if we could start notating, which sections of the Brown Act apply to which sections to the ordinance.
I agree. One of the projects that I would like to undertake in the future is to make a chart of the provisions and sort of show in one column what the Brown Act section reference is, what the old CPRA section is, what the new CPRA section is, and what the ordinance section is, so that there's a crossover chart. And again, where it makes sense for us to track the language exactly, that we should, and where there's a reason for us to depart, that we should do that. But so that it's a lot more clear, I think that would just help a lot. It's a big, it seems like it's pretty straightforward, but it's actually pretty complicated a task to go through. So that's why I haven't done it yet.
Yeah, it makes it more palatable for our decision makers also in approving the amendments, because if they could see that we're not reinventing the wheel, or we're not, inventing something innovative, that this already stems from
that we're drawing it from elsewhere, right? And then to the extent that we propose reordering sections of it so that it reads more logically and that we're moving things around, that we're not actually losing any of the substantive provisions. We're just saying that, that's now covered by another sentence added here rather than this whole section over here, much of which is duplicative. Exactly.
I think that might also just be helpful. Folks don't have time to read through the whole thing, So.
Well, I mean, I don't think there's anything wrong with both beefing up provisions where we might intentionally weaken one provision because we're trading off for something else, but so that the whole thing overall is a lot more readable and promotes compliance. That would be great. Because right now, let's be clear, it's not easy for anyone, whatever level of sophistication, to comply with everything in here. We are not making it easy.
Okay. All right, let's move on to 11.
Okay. So what I had on 11, I actually would make the two graphs A and B. I think I had some minor edits. Let me just read through it. In A, or the first graph, prior to any closed session, a policy body shall state I think just reason is fine. State the reason for the closed session and shall cite the specific statutory, striking a bunch of words, statutory or other legal authority under which the insert closed session is being held. In the closed session, the policy body may consider only those matters covered by the statement rather than in its statement. In the case of regular and special meetings, a statement shall be made in the form of the agenda disclosures and specifications required by Section 67.8. I would probably strike the words of this article. I think that's understood. And in the next sentence, also required by Section 67.8, and strike of this article. That's what I had for A. And in B, or the second graph, in the case of an item added to the agenda as a matter of, I think it's no longer called urgent necessity. I think it's imperative need. So I think I would use that language. The statement shall be made prior to the determination of serious injury instead of urgency. I think that's the current language. And then again, pursuant to Section 67.8, deleting of this article. And then the last sentence, nothing in this section shall require or authorize a disclosure, or maybe even dropping the A, shall require or authorize disclosure of information prohibited by, and I think I just alphabetized it to say federal or state law.
Okay.
That was what I had for 11. The other concept that I have that I didn't write up here, maybe it would go in the agenda descriptions. I'm not sure exactly. And Chair Wolf, Bruce, you'll recall that the Board of Supervisors in the last few years has updated its language for closed sessions, particularly in committee, where it previously would say something like, consideration of a claim or settlement of a claim for $200,000, whatever, right? Now there's an additional phrase that was added that says something like, related to an allegation of great bodily injury or related to an employment discrimination allegation or something, right? So there's some added verbiage about what the basis of the closed session is. That's, in my view, that's not currently required by the ordinance, but I think it should be. And so maybe that's a subsection C that could go here that, like notwithstanding, I'm just thinking out loud, notwithstanding any other provision of this ordinance, an agenda for a closed session matter shall include a brief general description of the subject matter. So essentially so as to permit meaningful public comment on the item. Because if all it says is we're going into closed session to consider settling a matter by giving somebody $200,000, I don't know who that is. I don't know what it's about. Maybe there's a reference to a court case. Maybe there isn't. But I can't really make meaningful public comment on that. So what the heck, right?
So you're talking about after they come out, if they were to take action?
No, because they can take action in closed session. So,
yeah, but they have to report back out what they did.
Right, but I'm saying that the agenda itself should say something about why is it that they're going into closed session, that it's based on, an incident or an allegation or a claim of employment discrimination or something.
Isn't that in A, in the first sentence?
Not really. That's really more we can do this based on, section 54957.6A of the Brown Act. It doesn't really require any more specificity than a legal authority.
Well, except in the second sentence, it says in the closed session, the policy body may consider only those matters covered in the statement. So,
but again, I don't have the solution to this right now. All I'm saying is that maybe there should be a provision C that requires some kind of generalized disclosure of the underlying subject matter. So if it's and it's particularly as relates to litigation. There may be other things that I can think about. For example, when a body is considering hiring a department head, I've never been interested in names, but I'm very much interested in the number of applicants, and to the extent that they've winnowed down the pool, kind of, we got 58 applications, we're down to 11, we're hoping to interview, 5 or 6. Mm-hmm. And
Okay.
I think we could require that in a way that doesn't disclose who any of the applicants are, or what the litigation strategy is, or what a fantastic real estate deal this is, et cetera. I think there are just some generalized concepts, and I'm happy to work with others to figure out how best to craft that language. But
Okay.
again, the idea is that a member of the public should be able to comment prior to closed session and say, yeah, that it sounds like you're doing a great job on hiring, or sounds like the pool's pretty shallow, maybe you should reopen the whole process again, or sure, the city should spend some money and buy that empty lot over there and turn it into a park, whatever.
Mm-hmm. Okay.
All right. Anyway, that's
sounds
what I
like
had on all that.
sounds like something interesting to add. I would like to strike a few words in the third sentence of A. It says, in the case of regular and special meetings, the statement shall be made, and it says, in the form of the agenda. I would just remove the words form of the, and just have it say, the statement shall be made in the agenda disclosures and specifications required. I don't think form of the agenda.
It's weird. Yeah, I don't know where that came from. That might be something that again came from the Brown Act. I don't recall.
That's actually not in our amended ordinance. That was stricken, those 3 words, in the latest version.
Oh, okay.
Yeah.
So we're on the same page with that one. Okay.
Great.
All right. 12.
But Allison on.
I just wanted to say.
Oh, go ahead. I'm sorry.
Yeah, 6711. The only thing other than striking those 3 words that we had recommended was, labeling the paragraphs A and B. We did that. And the suggestion for adding a 3rd paragraph with requesting that before closed sessions there be a reason stated for, or a description of the topic. That's an intriguing idea. We have a lot more to say about disclosures in 6712, but they're all after the fact, so that's how they differ. I don't have any suggestions for what to do before going into closed sessions. I've not really thought about it, but I'm all in favor of more disclosure than less. So.
And more description.
More description, right, exactly.
Maybe we can all take a moment, not tonight, but sometime, and look at a recent Board of Supervisors GAO agenda and see how city attorney claims and proposed settlements are handled there now, and maybe compare that to, 10 or 15 years ago, where I think it was not as good. Does that make sense?
Yeah, that sounds fine.
Victor, do you have any thoughts on how the board handles closed session matters, particularly in committee?
Closed session, it has to be a permitted subject. We notice it, and usually the city attorney will attend that meeting, and we will go into closed session, record it, and give it to the city attorney, and so forth. Is there something specific?
Well, in particular, that thing about the expanded agenda disclosures, the related to an employment claim or related to a sewer backup issue, whatever,
I'm not too familiar with that, because usually it's the conference with the city attorney regarding something. I'm not sure with other reasons.
Okay. Maybe it's more of a John Carroll question. We'll figure it out. That's fine.
I would suggest not John Carroll, but the city attorney themselves. What do we need to list on the agenda?
Yeah, you're right. No, I can talk to Givner about it. All right, we're cool. I think we're good on 11. And
okay, let's move to 12.
I appreciate Allison's thoughts.
Thank you, Allison.
So on 12, 12, let me just say 12 started out as a great concept of, like, after a closed session, what do you do and how much do you disclose and when and how, all of that. But it sort of added a couple of things in the Prop G amendments, so it's become a bit of a mishmash of pre and post. So I'm interested in, I think, making 12 be the post disclosures and moving the pre stuff elsewhere so that it reads better. For example, if you start out with 12A, after every closed session, a policy body may make disclosures. But then when you go to B5, collective bargaining, any collectively bargained agreement, which I'm not even sure is the right term, but whatever, any collectively bargained agreement shall be made publicly available at least 15 calendar days before the meeting of the policy body to which the agreement is to be reported. Blah. Anyway, it's just the concept there is great, but the way it's written and where it's placed is just kind of wacky, and we're expecting people to comply with this. All right.
Well, except, each of these sections are independent of itself.
Right.
Of the whole paragraph. So, but yeah, I understand what you're saying.
All right. So here's what I have going through 12. And again, I don't think we're going to come to full agreement on this, but at least if we can get the concepts out and people can think about it. So what I had for 67.12A, second line, disclose, I wouldn't say to the public, I would say disclose in open session any portion of its discussion, the charter, maybe lowercase c. Next sentence, the insert policy, the policy body shall, by motion and vote in open session, elect either to disclose no information or to disclose, I would say, such information rather than the information. So I would have it read, disclose such information as a majority of the members of the policy body deems to be in the public interest, period. Such disclosure shall be made by the presiding officer of the policy body or another person who was present in the closed session designated by the presiding officer to convey the information. Anyway, it's rewording it a little bit, but it isn't intended to change the idea.
Just don't want to, if you present something in an open session, it's then being made public. But we have experienced some occurrences where, say, documents were released publicly by accident and then were clawed back.
Okay. I would say that's a different issue, but I hear what you're saying.
I'm just saying to remove the concept of public record versus just announcing something verbally in an open session.
Right. No, I read 12A to be all about a verbal announcement. And I think that business at the end about it's either the presiding officer or somebody else. So it may be that the chair of the body turns to the attorney and says, okay, can you make the announcement? And the attorney says the body met in closed session, reviewed a proposed settlement agreement and recommended settlement, blah, 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 whatever. That it's actually somebody who's in the closed session who heard the discussion, who saw the vote, who's making a public report.
Let me ask a different question. I understand what you're saying. I understand. I just don't want to lose that public information, public record moniker versus, it says disclose to the public. So disclosing doesn't say verbally. It could be a written document of their action.
I have no objection to using the word verbally.
Yeah, but I don't want to make it only verbally. That's not how it's written now.
Then,
it just says disclose to the public.
Then
any portion of its discussion that is not confidential. It doesn't say verbal or otherwise. If it's written, then it's written.
Then we can say verbally in here. We could require that the minutes capture either exactly what was disclosed verbally or summarize that. There are a variety of ways to capture a verbal disclosure.
I'm not saying that the way it's written now is it doesn't speak to verbal. It could be verbal or written. So that's what I'm saying is not to then remove the option for it to be written.
Well, okay. If you read carefully what's in A, I think you'll find that most of what's here really lends itself to a verbal disclosure. And if there is a written disclosure, then I think that's covered in one of the B provisions. But Member Anderson has a thought.
Yes, I do. I would err on the side of not that much specificity, because whichever way you get the information out is the way I want the information to come out. Okay. So I would say to leave it as is. You'll disclose. You can do it any way you want.
And then, in fact, that would leave to the task force or to others to interpret that to say, was the disclosure meaningful? If you held it in the corner where only two people could hear it and it wasn't captured in the minutes, then it wasn't really a meaningful disclosure, as opposed to you made it very clear, you posted a document, you said, if you have any questions, call so-and-so tomorrow morning, whatever.
Yeah.
Okay. That's a good argument. Bruce?
Yeah. Okay.
My only other thought on 12A was to add a sentence at the end. Here's a good one for people to think about. The policy body shall also disclose the names of the members of the policy body and the names and titles, where applicable, of any other persons who attended the closed session.
Yeah, agreed.
Because right now that's captured in the minutes, or supposed to be, but it's not immediately disclosed after the closed session. And sometimes it's good to know who exactly was in the room. And if they want to say, well, and we had, 3 applicants for the department head position, and we don't want to name those names, fine. So maybe, we don't have to name those names. but certainly the members of the body, the senior staff, the commission clerk or secretary, the city attorneys, whoever. I'd kind of like to know who's in the room.
We've been before you return to the board, there were some changes in state law around disclosures,
yes,
around police activity in closed sessions. And so that gets to be a bit of a sticky wicket because that language is not in the Brown Act. It's somewhere in the
Penal Code 832.7
right,
or somewhere.
Yeah. Now, another issue is in A, it says after every closed session, a policy body may, in its discretion and in the public's interest. And then in the following sentence, it says the body shall by motion or vote. So the shall,
Yep.
You just can't do it. You got to do it by a motion or vote. But I'm just wondering about if we're going to, is it evolutionary at this point to that anytime there's a closed session that that there is always disclosure that of discussion or information that is not confidential?
There could be. I mean, if what you're asking is there any value in keeping the first sentence? I don't know.
I would just say instead of after every closed session, a policy body shall disclose
as much as possible. Yeah. Okay. Why don't I think about that? Let's think about that idea. And maybe after we go through, maybe not tonight, but after we go through the B1 through 5 sections, we will think of the generalized disclosure idea. Because B1 through 5 was really more specific to the different types of closed sessions and what types of post closed session disclosures make sense in specific rather than in general.
Okay, sure.
All right, so if we can move on to 12B.
Yep.
What I have for B generally is a policy body shall report, not publicly, but shall report in open session immediately following any action taken in closed session and the vote of not or abstention and the vote of every member present thereon as follows. There are different ways to finagle it, but I'm trying to require a report of the vote and that it's immediately following in open session.
Yeah.
So that there's no ambiguity that, oh, well, we decided to wait until next month because, no, you were in closed session, you did something in closed session, or you did nothing in closed session, but you need to report out in open session what you did and if there was a vote, how people voted. Bang.
Mm-hmm. Right.
Okay, so on B1, I think I just added California to government code.
Hold on. Let me ask this one question. This goes to attendance. So, because what may happen, just a scenario, you've got conflict of interest, where people should recuse themselves or they may be recused by the body for some reason. But if a person, it's kind of like in Congress where they say present, but they don't have to vote. I'm just, we don't know what's going on in the closed session.
Right.
So knowing who is going into the closed session is important, including the decision makers.
Right.
Okay. Because they're going to, if they may or may not take action in the closed session. I think it's worthwhile to know. I was going to use the word quorum, but I guess it would have to be So, who
Are
is
you
there a
getting-
quorum? Did somebody step out when the vote was made? When the motion was made, did they step out before the vote was taken?
Well,
That kind of stuff.
I think the language that I suggested might get you there, but maybe adding another sentence or working in the concept that in the event a member does not participate in a closed session matter due to a conflict of interest, that fact shall be stated and the reason for the conflict shall be disclosed. I mean, that's already in the Campaign and Governmental Conduct Code, but I'm not sure that it's that specific as to closed session recusals.
Yeah, no. I'm just saying besides a recusal, separate from a recusal. If you had 5 members of a 5-member body go into closed session, and they go to take a vote, and then just before the vote is taken in the closed session, one of the members or even 2 of the members decide, oh, I really don't want to vote on this. I'm going to step out and go to the bathroom in the middle of the closed session.
They can do that.
Right. And because it's not a public session, open and public, we can't see that. And so how do we assure that the people who are in the room are actually, are there and present?
Right. Well, that's why we'll read B carefully. Even as it's currently written, a policy body shall publicly report any action taken in closed session and the vote or abstention of every member present thereon as follows.
I know, but if a person went in and then during the vote,
fine,
they stepped out, then they aren't present anymore.
Then you rewrite it to say, and every vote held in closed session. So it's not about the vote of every member present, it's every vote taken in closed session.
Okay.
So if that's a 3-0 vote with 2 members absent, then that's how it needs to be reported.
What happens if it ends up being I don't know, like a 2-person vote?
2 out of 5 wouldn't carry it.
I hear you, but you don't know what's happening.
I would put that on you to try to wordsmith it.
Okay.
I think we can figure this out.
Okay.
But
just,
what we're trying to get at is a public disclosure of votes in closed session.
No, I understand.
Right. That's
but
the
it's
concept.
happening. It's happening behind, closed doors, out of the view of the public. The procedure. It's only procedural. I'm not discussing the details. I'm not asking him to reveal the details. I'm just discussing procedure. That's all.
That's fine. Can someone also make a note about resolutions in closed session? Because I've gone around with we get along, but we have a bit of a disagreement here. With the current PUC Commission Secretary, it is her view that resolutions adopted in closed session don't get posted to their resolution log in the same way as resolutions in open session. I don't get that. If you vote on something in closed session, even if it's a 2-liner that says settling a matter for $200,000 or recommending settlement to the Board of Soups, if it's a numbered resolution, it's a numbered resolution and it should be available. So, another sentence like any actual written resolution adopted in closed session shall be available in the same manner as written resolutions adopted in open session, period.
What constitutes a resolution over any other action?
That it's written. That I can point you to where you can find the resolution log, or you can look for it, Bruce. The resolution log for the PUC will have all the open session resolutions and will not have a link to closed session resolutions, which are numbered, but they don't post them.
Do they have anything do they take actions on anything other than resolutions, or do they just call all actions resolutions?
I suspect sometimes they act not on a resolution, but on a motion. But the point is that there are folks in city attorney land, primarily, maybe elsewhere, that, try to fuzz things up as much as they can in closed session because they don't want to disclose any more than they feel like they absolutely have to under the Brown Act or Sunshine. So the more we can shine the light on this area where it makes sense, right, without giving away, sources and methods and tradecraft and whatever else, right? Okay. But where there's an action taken and where you can say, yep, those 10 people went into a room, 5 of whom are on the body and the other 5 of whom are staff or city attorneys, here are the named people. Let's do that. If someone can articulate the countervailing harm to doing that, I'd love to hear it. But in general, I think the public is served by knowing what's going on. I mean, isn't that what we're here for? Yeah. All right. We don't have a whole lot more time. Can I just run through some more stuff here and then we'll maybe close it on 12?
Yes.
Okay. So on B1, just adding California to government code. Elsewhere in that graph, I had deleting the 4 words in open session immediately because I thought that was pretty obvious, but maybe it's not. I had some other clarifying language in the following sentence, like the policy body or the city's negotiator shall disclose that the fact of that approval, blah, blah, blah. Policy bodies vote thereon upon inquiry and at the first meeting of the policy body after the other party or the agent. Anyway, there's just some convoluted stuff there about the timing of disclosure. I don't feel a need to go through all the wordsmithing in 1. In 2, I think just adding policy before body, California before government code, and at the first meeting, insert of the policy body. In 3, a policy body may not approve any settlement that would preclude the release of the text. I don't care about soliciting. I care about approving.
Why may and not keep shall?
I read shall as being a requirement and may not means just that they may not. I don't view any, I don't see any difference between shall not and may not, and it's just shorter. If they don't have the power to do it, if they may not do it, then they have no power to do it.
But the idea kind of like, here is that the ordinance is ordering them to do it.
Right. So I guess I have sort of 3 levels of thing that if you're requiring them to do it, then it's shall. If you're allowing them to do it but not requiring it, then it's may. And if you're prohibiting them from doing it, then it's may not. But others may have different ways to word it.
No, that's fine, but shall means shall and may means may.
Right. So if you're requiring them to do it, then it's they shall do it. If you're
you're suggesting that shall be changed to may.
Only one in this case where it's not. So I'm saying a policy body may not approve any settlement.
Okay.
Okay. I'm not saying that they may. I'm saying they may not. Was that about as clear as? Never mind.
Yeah. I'd rather use a more definitive word like be disallowed or prohibited.
Okay.
And may not.
I'm open.
Or shall not.
Okay. I'm open to different ways to word it, but you get the concept.
Mm-hmm.
I want to finish up quickly so that we can get out of this. The long sentence in there, and I may have referred to this at the last meeting, that says any written settlement agreement and any documents attached to a reference that are publicly available 10 days before, yada, yada. acting to pay an amount of money less than $50,000. The agenda in which the settlement is discussed shall identify the names of the parties, the case number. Those two long sentences I would take out of this paragraph 3 and move those to appropriate places in 67.8 and 67.9. I think I referred to that previously. It just seems to me like, yes, we should do those things, but those are items either for the agenda or for making stuff available beforehand, not post-action disclosures. I had some other minor rewording at the end of 3. I think 4, again, some minor rewording, taking out immediately, because it seems like the intention is for it all to be immediate. I think I called it personnel actions rather than employee actions. And here's a good thing. If there is an executive compensation committee, or wherever this came from in 67.24 C6, I added to the end of paragraph 4 to read the amount, basis, name, and title of any recipient of a bonus or other performance-based increase in compensation, benefits, or both awarded to any city employee shall be reported in open session immediately following any closed session of the policy body at which such award is approved. Again, I don't know if this is actually happening, but if it is, this seemed like the right place to put that disclosure.
I need to see that on paper.
That's fine. I'm pretty sure that I just pulled that language from 24 C6 and reworded it slightly. Where's 24? One second. Yep. If you go to 24 C6, you'll find that wackadoodle stuff. All right, and then just to close out on 5, I think I proposed deleting paragraph 5 and moving that verbiage to the appropriate place in 67.9, because that also is a pre-meeting disclosure.
I'm sorry, 5 what?
In B5, the collective bargaining, the agreement has to be available beforehand. Okay. Yep, it should be. That's true. But I don't think this is the right place for it. That's all. Okay. Why don't I stop there with 12B? And maybe we won't get through C and D.
Yeah. I'd like to give Allison Washburn an opportunity to speak to this, and then we'll close out with that, if that's okay with you, Chairman Wolf.
Yeah,
Okay.
that's fine with me.
Okay, I made note of, I like the idea of moving the pre-stuff to 9. That makes a lot of sense. And by doing that, Member Pilpel, will that satisfy your suggestion that this whole thing can be better organized?
That's
okay.
Part of it, yeah.
Okay,
Yeah.
Got it. So looking at, I'm looking at the version that's on our website, the latest version, and we did not do detailed wordsmithing to any of this really until we got down to B3, and it was minor, very minor. And I'll let it go at that. But we added a whole section. We added E and F, I believe. So these have to do, E has to do with, let me just read my digest here. So E would deal with anticipated litigation. So that would have been the matter discussed in closed session. So what this asks that the policy body do is anything that involved anticipated litigation, the city attorney's office or the policy body shall disclose at any time requested into any member of the public whether such anticipated litigation developed into litigation, and shall identify the court case number and the date the case was filed. So this is only disclosing if it's asked to be disclosed. I would think it would be better to require that it be disclosed as a matter of course. Just an update. Hey, this happened, and then kind of closing the loop on something that was discussed.
It also helps with like a chain of command or a chain of process, because it goes from anticipated litigation into actual litigation, and now you kind of get it. Well, we can't discuss it. And they use an umbrella.
Okay, I want to move along because I have to leave
I'll come back
for
to that.
purely selfish reason, which we all know about.
Yeah.
Okay, so F, review of, so E is fairly straightforward. F is more complicated. Review of closed session justifications. So this is actually requiring this policy bodies, after these amendments have been passed, they have to go back and disclose all this stuff. But at any rate, for each closed session, the policy body shall maintain a record of the date and time, justification for the subject matter, and minutes, and blah, blah, blah. And at least quarterly, the policy body shall review these records and determine whether any part of the minutes, recordings, or other records can now be made accessible to the public. And the body will adopt a resolution stating the body has conducted the review and all the information has been made available. So this kind of ties it all up at the end. Okay, that could really solve some problems if that's done. And there's the last bit that authorizes this body to adopt any rules and regulations necessary to implement this section, which is new, saying, hey, bring us up to date, and then continue doing that down the road. So,
So if I may, on those, on E and F that Allison just propounded, I actually had versions of those as well, because I think I was proposing moving them from 0.8-1 A and B, where I thought when I was blowing up 0.8-1, I thought this was the right place for them. I think both are good ideas, but I think they both need a little more work to figure out. I had the language I had was for each agenda item for a policy body that involves anticipated litigation, the policy body or the city attorney shall disclose upon inquiry whether such anticipated litigation developed into actual litigation. If so, shall identify the case name, court case number, and the date the case was filed. Yes, so we agree on that, but the periodic review and reporting is more complicated, and it may be that something was anticipated, never developed into a thing, or developed into a thing 5 or 10 years later, and nobody really remembers. And I'm not sure if you want to make that a quarterly. You can make that into its own really complicated thing, or you can just make it this kind of generalized thing and see how that plays out in practice. I would suspect that there aren't that many bodies that cite anticipated litigation as a basis, and the number of city attorneys involved is relatively small. And if someone says, I'm really interested in whether that develops into a thing, can you just let me know if it ever does? And they'll say, yeah, how do I get a hold of you? And that'll be it. I mean, I'm not sure how much this really needs to become a full-blown thing. I don't know. Maybe not. We can continue to think about it.
Well, we do have that last statement saying that this body can
Right.
can draft regulations. I don't know if it isn't.
There are things that seem really important today, but by next week or 3 months from now, maybe it didn't develop into a thing, or it developed differently, and maybe we don't care, or vice versa, that something appeared out of nowhere and suddenly we care about it, but we didn't anticipate this a while back. I don't have the answer to this tonight.
Okay. This is Member Anderson, and the way I'm reading this section, it's like, yes, the first part of it is that for those things that are anticipated in litigation, if they become litigation, let us know what the numbers are.
Right.
The other part of it, 1 and 2 under F, speaks to the types of things you were speaking about with the PUC, where they do things in closed session. But now we're saying you've done it in closed session, you made a resolution that you're not disclosing. So come back to us quarterly and tell us why you can't disclose it now. So it keeps it from being in perpetuity,
Right.
hidden from the public. It's saying you have to justify why you're keeping it from the public. Am I reading this?
No, I think
correctly?
that's correct. I
Yes.
think that it makes sense that, down the line, a lot of things can be disclosed that weren't before. And, you never know who's going to want to know something.
Right.
And
I would say, as to resolutions, I can't right now think of any written resolution that confers authority to do something that shouldn't be publicly disclosable even now, and the concept below that is that entering into a settlement agreement, that settlement agreement also should be public, and any other things that you agree to in the course of litigation ultimately should be public. It's like, if it's being done on our behalf, on behalf of the public, we should know what that is, good, bad, or otherwise.
yeah, we can go back and look at all the mistakes that were made in a big project like this
Sure.
big street out here, or that tunnel over there.
Whatever. Yeah.
We'd learn a lot. Hey, I have to go. Thank
Okay.
you so
Yes.
much.
I had a couple of.
Thank-
I had a couple other quick things. If you need to go, you can hear it later.
I'll listen.
That's fine. But maybe if we can just finish this section upon reflection.
Could we make that like 5 minutes?
Yeah, no more than.
Thank you.
That's fine. So as to closed session recordings, I had moved that section from elsewhere. So I had that still reading: all closed sessions of a policy body shall be either audio recorded or audio and video recorded in their entirety, and all such recordings shall be retained permanently. Closed session recordings shall be made available whenever all rationales for closing the session are no longer applicable.
Mhm.
I don't know how workable that is, but that's still the concept, and I think that still makes sense. So that's what I had on closed session recordings. And then back on C and D for a second, I proposed streamlining the language in C. So it would say something like required reports may be made orally or in writing. And Bruce, we talked about that earlier.
Right.
Or other documents related to the transaction that were finally approved, not or adopted. I think things are approved in closed session, and that embody the information required to be reported shall be provided to any person who has made a written request regarding that item after the posting of the agenda or has made a standing request. That's what I had for C. It just cleans it up a little bit. And then for D, a policy body shall post a written summary of the information required to be reported pursuant to this section, or documents embodying that information. Maybe embodying is the bad word, maybe containing, whatever, by 4 p.m. on the first business day after the day of the meeting in the location, or maybe at the location where the meeting agendas of the policy body are posted. Because
Or
this
their
is
website.
that too. But the point is that there's already this requirement for a written summary to be posted, but it is, as far as I can tell, completely ignored. This is like one of the more obscure sections of the ordinance, totally ignored. And making that more of a hard and fast 4 p.m. on the first business day afterwards, the deadline, then they would say, and frankly, the Board of Supervisors and the Ethics Commission are the only two bodies I can think of that sort of comply with this by way of having the draft minutes of board meetings available by the next business day. And in the case of the Ethics Commission, by publishing what they call a summary of actions that's also available by like 4 p.m. the next business day that summarizes the actions. It's a good model that, and that's with regard to open session things. But with regard to closed session things, there's not much that gets done in closed session. But if you approve a settlement agreement by a 4-0 vote, somebody should be able to come back up here and tack on the wall, the body approved by a 4-0 vote, the attached settlement agreement at this meeting. Bang, and post it on the website. You're absolutely right. Anyway, that's what I had for closed sessions. I think we're good on 12. I would suggest that we do 9 and then back to 13 starting next time.
Okay.
That sounds
Do you have a copy, David? Do you have a copy of Allison's amendments?
I think I have access to it on the website, but it sounds like she's in the process of reconsidering some of that as well. I mean, I think these are all sort of works in progress.
Yeah, no, they are. But just so we have all of them, so we can, we're not overlapping or duplicating.
Correct. And at some point, I'm going to, surface my stuff as well.
Okay, great.
So there's more work to do, but I appreciate the discussion. Again, 67.9 and then 13, et cetera, next time.
Very good. All right, let's open it up for public comment, if there are any public to comment.
There is no one in the room and there's no one in the caller queue.
Okay, public comment is closed. There's no action on this item. It will be continued. And let's call the next item.
Item 7.
Yes.
Item 7, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
What say you all? Nothing heard.
Do we anticipate, absent a change in membership, that we would be back in June on our regular meeting date?
I don't know. That's
Okay.
a Chair LaHood question.
All right. So next meeting, June or unclear.
Yeah.
And hopefully Chair LaHood will be back.
Right. Okay. And there's no, I guess, no members of the public.
There is no one in the room and no one in the caller queue.
Very good. So no public comment for this item. Call number 8, please.
Item 8, adjournment.
Okay, by a rising vote, we are adjourned at 7, 9, 8, 7, 6,
14.
5, 4, 3, 2, 1, 7:15.
7:15.
Whatever works for you.
Mr. Young, can you please end the recording?